Okay, so it is a great pleasure to welcome Professor Sir Jonathan Montgomery from UCL Laws here today for our CHLS Seminar. Jonathan will be presenting a paper entitled More Law, Worse Medicine. Jonathan is a great friend and mentor to many of us here in the centre, and indeed the centre as a whole, and has inspired the work of many of us in the area of healthcare law, or health law or medical law, and we can have a debate about what it be called. Has had a huge influence on our work and thinking in this area. His contributions to the field include field-defining work around theorising the frameworks for healthcare law and how it is understood. And there's quite a nice reflection on that in a paper he co-authored with Margaret Brazier in a special issue of the Northern Ireland Legal Quarterly last year that arose from a centre event. Jonathan, in addition to his academic contributions, has made huge and wide-ranging public ethics or public service roles, for which he was awarded a knighthood for services to bioethics and healthcare law in 2019. He has been chair of and a member of many different bodies, including but not limited to the Human Genetics Commission, the Nuffield Council on Bioethics, Health Research Authority, and currently co-chair of the Moral and Ethics Advisory Group. Specifically, given the focus of his paper today, it is important to note that Jonathan is an experienced NHS chair. He is currently a chair at Oxford University Hospital Trust, and he was a member of the Morecambe Bay inquiry into maternal and neonatal deaths. And that provides some context for some of the discussion that we will hear today. So just to thank Jonathan for coming along and agreeing to give this paper. We're really looking forward to it and hearing what you have to say.
Thanks very much, Sheila. And it's nice to see so many friends. I think this is the first time I've actually managed to get to visit the centre, despite a few aborted attempts, and even now COVID gets in the way. So it's great to be here. I'm going to try and grapple with something that's bothered me for quite a long time, which is how best to understand the purpose of law when it engages with healthcare and the work of clinicians, especially doctors, which perhaps will be a bit of the focus of us today, despite the fact that I prefer to call it healthcare law. I'm not sure I've got a straightforward answer to this question. I'm not necessarily saying the answer is always yes, more law means worse medicine, but I want to raise some of the reasons why it worries me that that might be the case, and hopefully open up some discussion. And I'd like to start with a bit of self-image. I think we need to reflect on what we think about ourselves as lawyers, and also how clinicians think about themselves. So the idea of this slide is that it sort of portrays our best image of self and why we think we're doing something good in society and how that breaks down. And obviously this is very headline, but we tend as lawyers to hold on to the idea that society will be a better place if we can honour the expectations of the rule of law. And I think for our purposes today, the key things on that seem to me that the rule of law offers us a sense of order and predictability in social lives, so that we can hope that our social interactions will go smoothly. We can have enough mutual trust to plan our lives. The rule of law suggests that no one is above the law, and one of the challenges around the regulation of healthcare is whether it places some health professionals in some circumstances beyond the reach of the law. And we also have a pretty optimistic view of the position that judges may be able to take in terms of their independence of some of the challenges that the rest of us face most of the time, their propensity to be able to be objective and neutral in contexts where we have quite bitter disputes about moral values on some of the issues that we're dealing with. So that's the optimistic view. The pessimistic challenge would be the way in which the idea of the rule of law might collapse into ruled by lawyers, and we might not be sure that that's the appropriate way forward. And I want to raise a few questions about that a bit later on. There's a similar set of issues in relation to clinical freedom and the values that lie behind the health professionals. The claims that promote clinical freedom seem to me to be based on the idea that there are some difficult things, knowledge, skills, amount to clinical expertise, which clinicians aim to apply in the interests of their patients, not their self-interests. And they hope that applying that expertise in the interests of their patients ends up in the delivery of improved healthcare. The flip side of that, the dark side of that, you might say, is that if we take that too far, it might collapse into deference to doctors, and we might not actually get the application of expertise, or we might find that it isn't really in the interests of patients, or maybe it won't end up in the delivery of improved healthcare. So the challenge I want to explore this afternoon is about whether or not greater use of law is likely to push us towards the combined benefits of respect for the rule of law and the proper approach to the regulation of clinical freedom, or whether it might collapse into deference to doctors or the rule of lawyers and give us something that we're perhaps not so keen on. So just to set the scene, we could look at this through the voices of three Reith Lectures. So many of you will probably have heard Jonathan Sumption's Reith Lectures, in which he broadly argues in various ways that he thinks that law's empire has overreached itself. And he includes some of the leading cases from the Supreme Court over the past few years in relation to end-of-life care as examples of where the law has colonized elements of life that deserve to be, if not private, beyond the reach of detailed legal regulation. And that's pretty much the opposite to the arguments that Sir Ian Kennedy made in his Reith Lectures, published as The Unmasking of Medicine, in which broadly he argued that medicine left to itself couldn't be trusted. It was medicine that was overreaching, and the solution to that overreaching would be more activist legal regulation, which would ensure that medicine was held to account and that rule of law requirements were respected. And then in between, the Reith Lectures from Baroness Nora O'Neill, looking not primarily at legal elements of accountability, but more generally at the way in which we've increased accountability structures, the measurement and external scrutiny of the way in which institutions operate might not actually have added up to improving trust and trustworthiness, but may actually have created part of the problem that we're trying to solve in terms of the disintegration of our appropriate respect for expertise, subject to reasonable limitations. So these are deep and difficult issues. And I want to take you through some examples where it seems to me we might be able to draw conclusions about whether or not greater legal intervention is connected with improved or poorer medical care. So a key battleground is clearly the Bolam test. And I doubt there are many people listening to this who are not aware, but just to remind you, the Bolam test suggests that doctors are not liable when they've acted in accordance with a practice accepted as proper by a responsible body of professional opinion from a relevant specialty. And that Bolam test has been extended either explicitly or by implication into a whole load of arm's length regulation of medical judgment and medical practice, and for many is a key illustration of the failures of the rule of law in our area. So let's just summarize, I think, the strongest case for that. If you go back to the development of Bolamization in the 1980s, the high tide, you might say, of Bolam, we saw judges in a series of decisions saying that they weren't able to choose between schools of clinical thought, provided you complied with one. That was sufficient. They weren't prepared to examine closely the range of duties that health professionals had and subdivide them. That was the Sidaway case on disclosure requirements and has since been unpicked, as I'm sure many of you know, by Montgomery, which we'll return to later. They also decided that a responsible body of opinion didn't have to be a large one, and they showed considerable sympathy to the challenges in which clinicians were operating. That last bit, sometimes described as battle conditions. And many scholars and judges have interpreted that as essentially handing legal standards over to doctors, and have argued that handing standards over to doctors constitutes an abdication of the rule of law. So this would be, the argument that we need the law if we're actually to try and promote more effective medicine. But I think we need to be a little bit careful about not losing sight of the challenges that we have of our own self-image. I talked at the beginning about the way in which clinical freedom is an articulation of what clinicians would like to be like, and the rule of law is an articulation of what we wish law was like. But I wonder what happens in real life. So Sir Robert Francis, really important Mid-Staffordshire inquiry, but ended up with 292 recommendations, mostly of legalistic reforms. And I want to raise the question about whether, when we ask a lawyer and we get an answer that the law is the solution, we should be a little bit careful about taking that at face value. So it is absolutely clear that the Mid-Staffs inquiries, and there are clearly more than one, identified a whole series of things that were completely unacceptable. It's not so clear that the range of legal interventions that Sir Robert Francis proposed were likely to really address the challenges that he identified in things that went wrong. So broadly, we had fundamental failures of culture, failures of compassion, failures of management to identify that problems were there and put them right. And a major part of the analysis in Mid-Staffs, and there were elements of this also in the Morecambe Bay investigation that I sat on, was that instead of clinicians and management being focused on delivering high quality care to patients, they were worried about the external regulation, their reputation, whether they would get to foundation trust status, a whole series of pressures that I recognise from my NHS chair roles. But Sir Robert Francis's proposals were for a whole series of legal interventions. And here's a few of them. New criminal offences, picking up existing gross negligence manslaughter, but adding offences of willful neglect for those with people in their care. Noting there's malpractice litigation, but adding on a whole series of obligations that enhanced the external regulation, particularly through the Care Quality Commission. Special obligations to be transparent about things that went wrong. Duty of candour is the common phrase, but duties of candour is probably more accurate, because there's a whole series of them that were proposed and which have made them their way into the Care Quality Commission regulations. A whole series of enhanced personal accountabilities. So regulation for NHS managers, which was proposed, although still not put in place, reforms to professional regulation for the General Medical Council and Nursing Midwifery Council, including education reforms and recruitment reforms, and a new fit and proper person test. And the question I want to raise with you is whether, when you look at these working through, law here is part of the solution to those problems or part of the problem, or indeed raising new problems. And I just want to illustrate that with a couple of examples. So first of all, the fit and proper persons test. When I took up my latest position as NHS chair, I had to produce all my certificates to prove I had the qualifications I claimed on my CV. But I also had to persuade people that I'd never been privy to any serious misconduct, which ironically, I might say I was privy to quite a lot when I sat on the Morecambe Bay investigation, because that was precisely what it was all about, uncovering those things, but of course not in the legalistic sense of being a party to it. Now, on the face of it, we might think that it's entirely right that we want the right people dealing with things, but we should be worried about the biases that this might introduce. So here are a couple of reasons why I worry about good character tests. One related to healthcare law. Back in the 1915, the Central Board of Midwives found that a midwife who was living with a man who wasn't her husband was therefore not of good character and couldn't be admitted to the early midwifery register, now held by the Nursing Midwifery Council. And I don't know how many of you still read this case, but when I was a student, this was a case we were all made to read about the biases of judges, and this is a case from Lord Denning. Lord Denning was asked to, as he usually did, stand up for the little people against the powers that be. But in the Ward and Bradford Corporation case, his sympathies were on the other side. So a woman had been expelled from Teacher Training College because he's allowed a man to stay in her room overnight against the rules. And Lord Denning said, what a fine example to set for others. And she, a girl trained to be a teacher. I expect the governors and staff all thought she was an unsuitable person. She'd never make a teacher. No person would knowingly entrust a child to her care. So it raises a question about us being self-critical about what happens when we legalise some of these questions. What about the duty of candour issues? So the duty of candour requires health services, when they become aware of a notifiable safety incident, to notify the relevant person to give support to them. Notifiable safety incidents deals with unexpected incidents that, in the reasonable opinion of a healthcare professional, could result in or appears to have resulted in the death of a service user, or severe harm, moderate harm, or prolonged psychological harm to a service user. Now, this seems an eminently sensible thing for us to want to have happened, but it's not necessarily sensible to generate it through legal requirements. So here are some worries about what happens when we engage with enhanced legalistic regulation. We want people to be open and transparent when things go wrong, but we want them to do that because they're focused on the needs of the people that they're serving, their patients and their patients' families. But what we've done in the duties of candour is we've encouraged organisations to think about the definition of a notifiable incident, the question of what counts as a moderate degree of harm, and to worry about the Care Quality Commission coming in their inspection and deciding that the organisation has not appropriately honoured its obligations under the required duties of candour that are in place if they wish to continue operating as a healthcare provider. So actually what we've risked creating here is a set of legal obligations that encourage organisations to focus on the regulator, not on the patient, which is pretty much exactly what the problem was in mid-staffs, at least as I've just summarised it early on, that instead of worrying about getting things right, they worry about compliance. Now, this is absolutely linked in with the sort of idea that is attributed to UCL scholars, the positivist view that the essence of law, as John Austin put it, is a command backed by a sanction. If we want to have law, it needs to have some bite, and that's what makes it law, other than some regulatory, a different regulatory technique. But it's pretty hard to connect with the sense of moral agency that would lie behind compassionate care, which was what Sir Robert Francis argued we were trying to promote. So there's something about, do we actually undermine the virtues that we're trying to promote by regulating through sanction-backed legal rules? And I'll perhaps come back to that a little bit later if I have time. What about the fit and proper persons test? Well, the first thing that happened with the fit and proper persons test is that activists began to use it to argue that Sir David Nicholson, Chief Executive of the NHS, was implicated in the mid-staffs problems, although he had very little to do with that organisation in any of the roles that he had, and should therefore resign. And periodically, people write in arguing that this or that, this or other health service leader doesn't follow the fit and proper purpose test, and trusts are obliged to go through an assessment to try and decide whether there's any basis for that. So we may have created something that was aimed to ensure that the right people are in senior positions in the health service, but what we've actually done is to create some bargaining chips for harassment, which promotes the idea of a blame culture, again, completely in contrast to what was identified as needed from the mid-staffs inquiry. And then there's a question about whether that sort of regulatory intervention has undermined professional responsibility and agency and enhanced the managerial control over what doctors do, and encouraged us to think not in terms of the promotion of well-directed clinical freedom, but in doctors to think about how they're going to comply with external demands, which may or may not be morally well-founded. So we need to ask ourselves then, if we end up using the law as a tool, or maybe, depending on your perception, which end of it you are, as a weapon, then we're in a position where law is essentially amoral without intrinsic merit. And what we need to worry about most of all is the question of who wields it. We can see that in abortion law. We can see litigation from both pro-choice and pro-life sides. We can see how abortion gets sucked into culture wars. And if I get any questions about that, I'll just ask Sheila to answer them, because it's her work that I give my students to talk about that. We see it in end-of-life care, the development of test case litigation, which raises serious questions about access to justice, the funding of litigation, when test cases generally reflect interpersonal problems and victims, and when they're being used as a mechanism to avoid the fact that democratic processes are not ended in the results that activists are after. That element of litigation has stretched our understanding of the appropriate response to separation of powers in these areas of morally contested choices. And we've seen a little bit of oscillation in the Supreme Court, which I won't dwell on now, but very happy to pick up in questions around what exactly is the right way of understanding separation of powers between the legislature and the judiciary. And we see an odd dance around this, in which the Supreme Court in Nicholson asserts jurisdiction, but then declines to exercise it in Conway. And in the Northern Ireland abortion case, struggles to reconcile the fact that it was fine to get engaged in views on abortion law for human rights issues, but it was okay for the court not to pursue the suggestion it made that it was going to take control over the human rights elements on end-of-life care and physician-assisted suicide. So we've got ourselves, I think, into some difficult waters as we assert more law in these areas, which deserve considerable study. So taking stock of where I've got to so far, I think I've argued that legal interventions may end up undermining good medicine. They may turn out to be a vehicle for imposing prejudicial values, my particular example being a minor one, but we'll perhaps come to some other things in a moment or two. We may enhance the move away from patient-centered ethics into prudential compliance by increasing the regulatory scrutiny. We may actually, by way of regulation, increase the risks of blame cultures, which are thought to be a major part of things going wrong, not being opened up and not being addressed. We may have encouraged managerial control over clinical judgment. That, I think, is something we might have a discussion about whether it's necessarily bad or good. And we've also seen a risk that litigation enables the privatization of public policy, which we can also see with the proliferation of private members' bills in the context of healthcare law, all of which should make us perhaps pause for reflection when we assume that it's a good idea that we get involved in these things. So let me reflect on a few areas that make me pause when I have a look at it. First of all, mandated court referrals. So a couple of areas worth a bit of discussion here. In relation to the child law cases, we have the David Glass case in Portsmouth, reminding us that human rights requirements push us to putting in front of a court decisions that may involve the withdrawing of life-saving treatment. We have the challenges around whether or not treatment is effective that we see in the Charlie Gard and the Alfie Evans cases. And I can talk at greater length about my views on this a bit later, but it seems to me that what we identify in those cases is an important role of the law to force clinical accounts to be articulated in an independent, objective way in front of an adjudicator who can test them out with cross-examination of evidence, so that fundamental legal rule of law opportunity here is about providing a forum for accountability, but not necessarily about determining the outcome. Now, we can talk at great length about whether or not the playing field is even, whether sufficient equality of arms in relation to that. And we also discussed whether we look at those cases and think that providing that sort of forum has actually reduced the heat or maybe enhanced it, and whether it's an effective way of avoiding what elsewhere I've called the tragedy of these cases, where the excessive desire to do the right thing, whether that's on behalf of optimistic doctors or the parents of children, causes ultimately harm to the protagonists. We can argue about whether it's effective or not, but my main interest here is whether or not we should be pushing this forward. And I want to reflect on the mandated court referrals in the context of older persons care. So many of you remember that in the Bland case, they identified the importance of bringing patients who were in a permanent or persistent vegetative state, for whom life-sustaining treatment was under consideration of withdrawal, to court. They argued that if you brought these things to court, it would enhance public confidence because they could see the debates going on about the right thing to do. And also it would give an opportunity for us enhancing legal regulation by giving judges the opportunity to develop rules. That latter bit was undermined as increasingly you saw acceptance of professional guidelines in the decision-making about when treatment could be withdrawn. And the most recent discussion of that is probably bested from Aintree and James. But we've also seen the harm that mandatory referral has created by delaying withdrawal of treatment decisions, even when they're not controversial. And NHS Trust Against Why identified that the idea that some category-based referral requirement was what the law required should be relaxed. And we're now grappling with how to get the detailed assessments of which cases come to court and which don't. They initially withdrew the practice direction and have quietly reintroduced one. But that's an example of where what appeared to be an extension of court oversight had unintended but detrimental effects for the patients and their families by creating a rather rigid mechanical approach to dispute resolution or oversight, much as lawyers have described going wrong in clinical care when the live before care pathway became mechanically implied and undermined the patient-centered nature of palliative care. So we should worry about the possibility that legal intervention creates all the rigidity that we dislike about algorithms in our current context. So let's go back to Bolam. I don't think we should give up on Bolam, but I think we should think carefully about how we use it. So very briefly, why do I think we shouldn't give up on Bolam? Fundamentally, what the Bolam test does is to force an articulation of things that are previously covered up, because you have to justify what you have done to a group of peers, and it enables then you to integrate a mixture of medical and legal standards where the relevant expertise is in play. I can try and defend that in a bit greater length later on, but the key here then is it all then depends on our understanding of expertise and our understanding of what happens in relation to clinical judgment. Clearly a complex issue, but to simplify it slightly, there are clearly issues about knowledge, issues about scientific basis for claims of expertise, and in those cases you can assess those questions about an evidence case. But there are also issues of expertise and clinical judgment which are all about the ability to exercise a judgment that can't necessarily be predicted in advance. And what the Bolam test does is to force those experts to explain what they've done and enable them to be assessed by a suitably qualified person. Those people who see Bolam as abrogating the role of law worry about that because they say that suitably qualified person is simply another doctor and doesn't have any degree of challenge. Those people like me who worry about excessive legalization worry that what we are doing is moving the suitable person test to be a lawyer, and I'm not sure that's necessarily the right thing. Why not? Well, let me say a few things about Montgomery and Lanarkshire. Not all the things I think about that, but just to pick up some questions about the challenges around reasonable alternative and variant treatments. So I'm not wanting to challenge the basic tests for informed consent and disclosure from Montgomery, but I am worried about where it takes us in terms of who is best placed to determine which treatments are reasonable alternatives or variants. Here's why. Just picking up the fact that in Montgomery, the Supreme Court reached the conclusion that the caesarean section for Mrs. Montgomery in the circumstances was a reasonable treatment, even though it was outside of the relevant clinical guidelines, and even though there was expert evidence before the court that supported the clinician's management, and despite the challenge from the Scottish courts that the view that prevailed in Montgomery amounted to saying that as a matter of law, so not a matter of good practice or medicine, but as a matter of law, neither reassurance nor even deferment of a final decision can qualify as available options for a treating doctor once a patient evinces any generalised anxiety or concern, a challenge which I don't see the Supreme Court really answered. So this is a very brief summary of the sorts of risks around caesarean section that NICE, National Institute for Clinical and Healthcare Excellence, has identified. Intensive care following childbirth, hospital stay following caesarean section, incontinence following caesarean section, mortality rate comparisons for vaginal deliveries rather than caesarean section, and the possibility of moving to a high dependency unit or intensive care after caesarean section. If you look at the consent forms that hospitals use for caesarean sections, they run to some pages. If you look at the version that you would do on the back of the Supreme Court case, it would say that the risks involved in an elective caesarean section for a mother are extremely small, and for the baby, virtually non-existent. So this seems to me that the Supreme Court, whatever you think about other elements of my criticisms of Montgomery, Supreme Court has taken to itself an assessment of science that it is, singularly, it seems to me, ill-qualified to look at. Now, I don't want to push this too far, because since Montgomery, you can see that the way it's being applied in the courts is much more closely related to what I would hope for in relation to evidence-based practice. So here's an example from Guy's and St Thomas's, where the identification was of how to read a CTG, the risks involved of fetal well-being. They didn't think that the fact that someone from outside might think this was problematic raised an obligation of hospital staff to raise the question of caesarean section. And nor did they think that a woman who said, "Please just chop me, what are you waiting for?" was demanding a caesarean section, as opposed to expressing pain. I apologise to Sheila for raising these slides in this context. The key question here is that the court in Guy's and St Thomas's continued to think that when you're addressing with a maternal request for caesarean section, it was appropriate still to go back to NICE guidelines and appropriate for professionals to use their assessment about what those mean, and not the assessment that the Supreme Court operated in the Montgomery case, which was a somewhat different interpretation about what the NICE guidelines meant than many health professionals do in terms of the expectations of maternal requests caesarean sections. I can talk at greater length on that because it's a live issue in Oxford at the moment. But let's save that for questions. Where does that leave us post-Montgomery? Well, it seems to me that what we have post-Montgomery is a disaggregation of 4 steps in the discussion. What are the options? Now, Montgomery itself pushes judicial insertion into that, as I've just described, but post-Montgomery, it seems to be recognised that in view of the orthodox principles, we're looking for identification of treatment options as essentially being a matter for clinical judgment, as are an assessment of what risks are associated with them. Montgomery tells us that the decision whether or not to advise women and patients of those risks is not to be judged by clinical judgment, but it's to be judged against what it was that patients would think was material. It also seems from post-Montgomery cases, as when it's pushed about how you communicate, that we've moved back to recognising that this requires quite a lot of skill, albeit that's not quite what was said in Montgomery itself. But even more importantly, what we've seen since Montgomery is now the reissue of professional guidance. The most recent issue of consent guidance has come out in the past month or so, and reflects a process of co-production. This to me is pretty important. So we've seen this very importantly in the GMC end of life care. We've seen it in relation to the guidance on confidentiality, where I chaired the task and finish group and can speak in a bit more detail. And we've now seen it in the consent guidance that Deborah Bowman steered through. And the key thing here is that it's not a process of professional dominance in the way that Ian Kennedy imagined and possibly was when Ian Kennedy gave his Reith lectures. So this guidance is produced from a number of sources, identifying what problems doctors identified that they needed solutions to, compliance with the legal parameters and the cases that came through and statutory provisions, and also testing out with various stakeholder groups, patients, carers, including disadvantaged groups, what they needed from guidance, and ending up with a process which is pretty defensible in a democratic society as a way of norm creation, which is neither judicially dominated, nor is it professionally dominated, nor is it just a matter of patient demands, but it's an attempt to co-produce a decent normative structure. So that leads me to think that there are some really quite fundamental issues at stake as we grapple with whether or not legalizing these areas is a good or a bad thing. And I think they're fundamental questions of legal theory and how we understand the role of law and the rule of law. So are we interested in the rule of law pointing to norm creations, or are we interested primarily in thinking about the law as a remedial process which attempts to put wrongs right? Are we interested in good practice, or are we interested in responsive interventions from justice? There's a big issue about how we understand the gap between easily identified legal rules, and Charles Foster and Jose Miola have argued strongly that part of the problem of legal regulation, why the legal regulation doesn't meet rule of law requirements in their view, is that we have too many gaps where legal rules don't dictate the outcome. And they argue that amounts to there being an absence of norms. Well, as some of you will know, I completely disagree with that process. And it seems to me that actually what you do is you move to a different type of norm creation, and you rely on the fact that there is clinical guidance, there are professional values, and I describe that as a thesis about the integration between professional norms and legal norms, which is very much illustrated in what I've just described about the co-production of professional guidance. And my view on the position that Jose and Charles take is essentially it puts the different professions in competition with each other, whereas we might be much more productive if we thought about collaborating in the norm creation. I see a lot of that from the point of view of the health professions. I see a bit less of it driven by the courts and by lawyers. If we're interested in this collaborative process of norm creation, we're wanting to explore the extent to which actually we can get a common understanding of what is expected of people. And our interest in the rule of law is about whether it provides sufficient reasons to trust that other people will similarly abide by those common understandings and expectations. And we get that primarily not from external regulation, so much as the common belief that these are sensible rules to follow. So are we looking for a community based on common norms, or a community based on the prudence that we might come to harm if we don't follow those norms? That fundamentally is a classic set of issues about legal theory and positivism. So let me end with a couple of slides on how we might think about this. One is about how do we represent the connections between the two. So the UCL Bioethics and Medical Law Society combines the traditional symbol from the Greeks of medicine, the rod of Asclepius, with the scales of justice. So the scales of justice essentially claim the objectivity You'll remember they're often held by someone who is blind, so that they identify the equality before law. And they're associated with the Greek goddess Dike, who is a goddess all about retribution and putting things right that have gone wrong. There's another relevant Greek goddess, Eunomia, whose symbol is the scroll, and who is the goddess not of putting things right, that type of justice, but the goddess of good order, so a well-ordered society. Bottom right-hand corner, you have the coat of arms of Baroness Hale, with crossed scrolls, which I'm guessing indicates that sort of idea that what she's after is good ordering of society and the role of law in contributing to that. And then you have the rod of Asclepius with the scroll intertwined around the staff and the serpent around the snake, which is my attempt to represent graphically how it seems to me that we should hope that law and healthcare interface. That's to say, they should be closely entwined in a common project. Now, of course, that all depends on your expectations about what is possible. I sometimes say to Jose Miolo, it seems to me the key difference between us is that I spend most of my time with health professionals and have a high opinion of them, and he spends, and a low opinion of lawyers, and he spends most of his time with lawyers and has a high opinion of and a low opinion of health professionals. And I don't want to reject the fact that that is a serious question. So I want to end with a quotation from Martin Luther King. This is from a speech he gave in Newcastle when he got an honorary degree. And it sort of challenges the optimistic assumptions that I'm making. Because I've argued that law is not easily compatible with morality because it underlines moral agency, pushes people to a compliance regulation. But Martin Luther King pointed out that it might be true that morality can't be legislated, but behavior can be regulated. It might be true that the law cannot change the heart, but it can restrain the heartless. It may be true the law cannot make a man love me, but it can restrain him from lynching me. And so while law may not change the hearts of men, it does change the habits of men if it's vigorously enforced. And through changes in habits, pretty soon attitudinal changes will take place, and even the heart may be changed in the process. So it seems to me that it's not obvious what the answer to my question is, but it is clear to me that it's not straightforward, and I'm looking forward to an opportunity to discuss that with you all. Thank you very much.
So thank you so much, Jonathan, for that. And if everybody would like to go to the reactions button, they can do a virtual clap as we end the recording.